If you're still not totally comfortable with the relationship between the state and federal court systems, this short video may help clarify it for you. Now, I'm going to focus on the process for appealing an individual case. So you file a single case, and it goes through several layers of possible appeal. I want to differentiate this and separate it out from the concept of binding precedent, which is the idea that a court's opinions may be binding on other courts in future cases. For now, we're just going to separate those two out and focus solely on where can you appeal a single case. Now, to show this, I'm going to draw it out and walk through each of the stages using an example case. So we're going to start with a state court system. Now, this is going to be a prototypical state court system. State court systems can take some different format, but this is the basic design that we can think of. So we're going to start out with the state trial court. Let's assume that this is a case involving trademark infringement, and the plaintiff is asserting the trademark infringement case based only on state law. There are state laws that prohibit infringement of someone's trademark, and you can file your trademark claim based only on state trademark law. So the plaintiff files the case for trademark infringement in state court, and it's filed in state trial court. For the sake of discussion, let's assume that the trial court judge grants summary judgment of no trademark infringement. As a matter of law, the trial judge concludes there is no trademark infringement in this case. The plaintiff, dissatisfied with that outcome, appeals to the state intermediate appellate court. In this instance, the intermediate appellate court reviews the grant of summary judgment and concludes that the trial judge was correct in granting summary judgment of no trademark infringement under state law. The case could then be appealed once more to the state Supreme Court. If the state Supreme Court affirms the decision of the intermediate appellate court, then the case is over for the plaintiff. There's nowhere further to appeal those state trademark claims. The state Supreme Court is the end of the line for the state trademark claims. Now let's look at a case that's brought in federal court. In this instance, perhaps the plaintiff is bringing federal trademark claims. You can bring trademark infringement claims under federal law. There's a specific portion of the federal law that's called the Lanham Act that allows for federal trademark infringement claims. Here, the plaintiff files in federal district court. Now, let's assume that the procedural outcome is the same as it was in the state courts. The district judge grants summary judgment of no trademark infringement. Once again, our dissatisfied plaintiff appeals, and this time to the federal appellate courts. And like almost all federal legal issues or decisions in federal trial courts, this case is appealed to the regional circuit, in which the district court is located. Now, let's assume again that the Federal Court of Appeals affirms the decision of the district court judge. And so the plaintiff seeks review, this time in the United States Supreme Court. Now, the United States Supreme Court doesn't have to take the case, doesn't have to review the decision of the circuit court, but perhaps it does, and perhaps once again it affirms the decision to grant summary judgment of no trademark infringement. Once again, this is the end of the line for our particular plaintiff. Now, let's add one more complexity. It turns out that trademark claims can be brought under both state and federal law. And so it's entirely possible that in our instance, the plaintiff brought both state and federal trademark claims in the federal district court. Once again, though, the appeal pathway is exactly the same as if it had only involved federal claims. The dissatisfied plaintiff could appeal to the courts of appeal, and then if the dissatisfied party didn't like the decision in the court of appeal, could seek review by the United States Supreme Court for both the state and federal trademark law claims. Let's go over now to the state court system, because due to concurrent jurisdiction, the state court could also hear both the state and federal trademark claims. And so in this instance, if the plaintiff brought the state and federal trademark claims in the state court and they stayed there, the dissatisfied plaintiff could then appeal to the intermediate appellate court and then once again to the state Supreme Court. Here, there's one additional twist, which is that the dissatisfied plaintiff could seek further review of the issues of federal law by the United States Supreme Court. So while the state Supreme Court would be the end of the line in this particular case for the state law claims, for the federal law claims, the dissatisfied plaintiff could petition the United States Supreme Court for further review. And in this instance, the U.S. Supreme Court could then decide those issues of federal trademark law. What's not possible in this case is to have review of state court decisions by federal courts other than the Supreme Court, or to have decisions of the federal courts reviewable by the state courts. So for example, it's not possible to seek review of the state trial court decisions in the U.S. Courts of Appeal, nor is it possible to seek review of the state Supreme Court decisions in the federal courts of appeal. The only point at which you have review of state courts in a single case is by the United States Supreme Court, and once again, only on issues of federal law. Now, again, to emphasize, this is the process when you're talking about appeals in a single case. This is a little different than the concept of which court decisions do other courts have to follow in future cases. That's a more complex issue, but it does have many parallels to the process of appeal. Because due to the way that cases are appealed, decisions of higher courts must be followed by lower courts. So for example, a decision by the U.S. Court of Appeal in a particular regional circuit must be followed by the district courts within that regional circuit. Similarly, a decision by the United States Supreme Court must be followed by the courts of appeals as well as the federal district courts. And a decision by the United States Supreme Court on an issue of federal law must be followed by all other courts. This is the notion of binding precedent. The twist here comes from the idea that when state Supreme Courts make determinations about state law, that's precedent as it gets applied by federal courts. Now, this is a little more complicated, and we're going to wait to talk about this in civil procedure until the end of the course. For now, I just want you to recognize that when we're talking about the process of appeals, appeals of state court decisions go through the state court process, and appeals of federal court cases go through the federal process. And the only place at which they intersect is here at the top, involving the United States Supreme Court, and once again, only involving issues of federal law. I hope this clarifies things for you. If it doesn't, leave me a comment, send me an email, or come to my office hours, and I'm happy to talk more.